We've learned that many landlords may not be aware of the strict tenant screening requirements for rental property located in Cook County, Illinois, which happens to include the cities of Chicago, Elgin, Arlington Heights, and several more. So in this episode of American Landlord, we are going to discuss the legal requirements imposed on landlords when using criminal records in Cook County, Illinois, to screen applicants for tenancy. This video is brought to you by RealSerious.com, where landlords and agents can screen tenants in Cook County and anywhere else in the USA. In 2019, the Cook County Board of Commissioners amended the Human Rights Ordinance with what is called the Just Housing Amendment, which is intended to, first, prohibit housing discrimination based on an individual's covered criminal history, and second, required landlords to perform an individualized assessment of an otherwise qualified individual's criminal history prior to denying them any application for housing. Now, there's actually a lot to this ordinance, but we're only going to highlight its key components. So if you're a landlord, you should review the entire ordinance just to make sure you are fully informed. To begin, it's important to note that no residential landlord is exempt from the Just Housing Amendment, so it applies to someone that owns one rental house or someone that owns hundreds. This includes those that even sublease their units. So, if you're the primary tenant and you decide to screen an applicant for subleasing your unit, then you are also bound by these local requirements. So, what exactly are the Just Housing Amendment requirements? They are as follows. First, landlords cannot include a checkbox on housing applications that ask whether an applicant has a criminal background. Second, before even accepting an application fee, a landlord must provide the following information: tenant selection criteria, which describes how an applicant will be evaluated, a notice of the applicant's rights to dispute inaccuracies relevant to criminal history, and to provide evidence of rehabilitation or other mitigating factors related to their criminal background. And finally, a copy of Part 700 of the Commission's procedural rules, or a link to the Cook County Commission on Human Rights website with the address, email address, and phone number of the Commission. This is something we will link in our description. Now, once a rental application is accepted, here is an outline of the required steps. Step 1 is the pre-qualification. During this step, a landlord may screen a tenant to determine whether the tenant satisfies all the application criteria, such as income, rental history, credit score, pets, and so on. Criminal background checks cannot be performed during this initial step. When the first step is completed, the landlord must then either pre-qualify the applicant based on all criteria except those related to criminal history, or deny the application based on failure to satisfy the pre-qualification criteria. So in other words, if the applicant doesn't qualify because of income, their prior rental history, their credit score, their pets, etc., they must be denied at that point. Step 2. This involves the criminal background check. Only after the landlord pre-qualifies an applicant may a landlord conduct a criminal background check. Criminal history that is more than 3 years old may not be considered. Arrest records that did not result in a conviction may also not be considered. And if a conviction is found, the landlord must then complete an individualized assessment. So what then is an individualized assessment? It's a process by which a person considers all factors relevant to an individual's conviction history from the previous 3 years. An individualized assessment is not required for convictions that are more than 3 years old. Factors that may be considered in performing the individualized assessment include, but are not limited to, the nature and severity of the criminal offense and how recently it occurred, the nature of the sentencing, the number of the applicant's criminal convictions, the length of time that has passed since the applicant's most recent conviction, the age of the individual at the time of the criminal offense occurred, evidence of rehabilitation, the individual's history as a tenant before or after the conviction, whether the conviction was related to or a product of the applicant's disability, and if the applicant is a person with a disability, whether any reasonable accommodation could be provided to ameliorate any purported demonstrable risk. Now, it's important to stop and go back and focus on evidence of rehabilitation. So what is that, and is a landlord required to consider that? Yes, a landlord must consider any evidence provided by an applicant showing any of the following: completion of a returning citizens program, job readiness training, supportive services that assist with the transition back to society, completion of a GED or other education programs, report from a correctional facility, employment, and personal recommendations. So now you may be wondering, how long does a landlord have to make a final decision? So once the application process has been followed and is complete, the landlord has 3 business days from receipt of any dispute or rehabilitation information to accept or deny the application. Any denial of a housing application or a continued lease that's based on an actual criminal conviction must then be submitted in writing and provide the applicant with an explanation as to why the application denial was necessary to protect against a demonstrable risk of harm to either personal safety and/or property. Finally, what happens if a landlord fails to comply with this just housing amendment? If the Cook County Commission on Human Rights finds a landlord to have violated their ordinance, the penalties may include compensatory damages and attorney fees, as well as commission fines. If you would like to screen your tenants and conduct a credit and criminal record search that's compliant with the 2-step process required in the Just Housing Amendment, you can visit realserious.com.